is that knowledge. Oh, look at that. Cool, okay. Let's talk about Albury and Maturin. This question, I think, where you'd start from is you would say, what is it that Maturin has to do? What is the contractual obligation that Maturin has and is arguably breached? What did Maturin have to do? Yeah.
Have the tank at 90%, so it's clause 4 that 90% capacity share.
Yeah. So under clause 4, Maturin guaranteed that the aviation tanks at the airfield will be 90% capacity each day of the term of the contract. Great. And how long was that contract for? I think it's up the top. Anyone figure out how long it was?
7 years.
7 years. Great. Where does it say that? Can't remember. It was a 7 year. Oh, here we go. Via pipeline to Albury for a period of 7 years starting 1st of October 2018. Great. So a 7-year contract under which every day they had to ensure that there was enough fuel at the airport that the tanks were 90% full. Great. Okay, so that's the obligation. What's the event that's occurred, or what's the potential? Why has this obligation not been fulfilled? What happened? Yep.
Due to the extreme weather, the pipeline can't supply any more fuel to the airfield.
Yeah, great. For how long?
6 months.
Great. Okay, so there was an event, a weather event, a storm, which damaged the pipelines for 6 months, which meant that petrol could not be provided. So the reason that's important is because you're trying to figure out, okay, is there a breach here? Prima facie, there is a breach. You promised, you guaranteed 90% full. You failed to do so for 6 months. And Maturin, as we see at the end here, is saying it's not responsible because the pipe was damaged not through any party's fault. And that the contract is at an end. So that's giving it's giving you a clue that this is a frustration question, because I didn't write it in the end there about whether it's a frustration question, but hopefully that final paragraph would give you the clue necessary to know this is a frustration question. Okay. So, when you're answering this question, I think you would start off and say, whether Maturin has breached the fuel supply contract depends on whether or not the contract was frustrated by the weather event and breach of the pipeline. And then you'd say, frustration is a defence against a claim of breach of contract when performance under the new circumstances would be radically different from that contemplated by the parties. Davis contractors is your case that you would use to cite that. Okay? You could then say, in order to determine if the performance is radically different, the New Zealand Supreme Court has endorsed the multifactorial approach in Planet Kids. We will look at, we will examine this fact scenario in light of that multifactorial approach or something like that. The point is, you don't want to spend too long on that law section. Okay? You can almost pre-write that law section because it's just a statement of what the law is. You don't want to spend too much time on that because you've got marks for identifying that's a frustration question. You get marks for identifying the law correctly, but where you're going to get most of your marks is by analysing these facts. Has it actually been frustrated due to that event? Okay. Now, I'm not going to go through and write the whole essay, but I just want you guys to provide some arguments either for or against, and there are arguments for and against, why this contract is frustrated or not. Oh, sorry, I'd just say one more thing about the law point. I would also write in there something about that frustration is a high threshold. It is hard to prove frustration. The New Zealand Supreme Court in Planet Kids says that, because that necessarily influences whether or not you ultimately conclude that the contract is frustrated or not. Cool. Okay, arguments for or against why this contract is or is not frustrated. What will you point to, or what factors will you look at arising from these facts? Yeah.
Looking at the clause 3 sort of terms of the contract, the guarantee in clause 4 is predicated on them being able to supply the fuel via pipeline.
Okay.
There's a presumption there that a pipeline will be able to be utilised, will be able to work. And while pipelines do leak from time to time, and those are easily repaired, this is something completely different. A storm coming through, destroying the pipeline, destroying the method that they were going to be able to use to continue the guarantee. And so you could, I think there's a stronger argument there that the circumstances and the underlying presumption that this pipeline was there, that what the contract was predicated on, has been completely changed because of the storm.
Okay, great. So, argument for a frustrating event, you have the requirement that Maturin provides it by pipeline. The pipeline has been destroyed by a large weather event, and the damage is so severe that it takes 6 months to repair it. That this is the sort of, not the sort of thing that the parties would have contemplated when they entered into this contract. Minor breaches, yes. Leaks, perhaps, but not a destruction of the pipeline of this magnitude. Great. Yep, that is an argument for why, certainly an argument that Maturin would run why this has been frustrated. Great. Other points? Yeah.
You could argue that the delivery method being by pipeline is something of a formality, and looking at the previous negotiations that were conducted in entering into the contract, what the parties really wanted was a guarantee of fuel supply. And as seen by the facts, there's still some trucks that can take the fuel there, and even though it's a lot more harder,
Yep.
the guarantee to get fuel there is still possible.
Okay, great. Okay, so you'd say that the point of this contract for Albury was that requirement of having the fuel on the airfield. They don't actually care how it's arrived there, that it's a guarantee for that fuel for 90%. And the fact that it's more onerous now on Maturin to provide that is not in itself grounds for frustration. Davis contractors, merely because a contract's more onerous doesn't mean that it's frustrated. Great, okay. Excellent. Other points or issues or facts that you would point to? Yeah.
Would you say the contract's not radically different because during the negotiations, Maturin was worried that Marsden Point might shut down and have no other way of making up the supply chain?
Yeah.
And even though it's not Marsden Point that's being flooded away, they clearly knew there was a risk in that single linear supply chain being broken and entered it without providing for that risk.
Great. Okay, that's a really good point. So, in the negotiations, it was clear that Maturin was concerned about the ability to supply the fuel through the supply line. They knew that there was a risk that the supply chain would be disrupted. And knowing that risk, they still entered into a contract where they guaranteed to supply the fuel every day. And not only that, how long did they do that for? What was the term of the contract? 7 years. It's a very long-term contract. And the point about a long-term contract is the longer it is, the more possibilities there are for things to go wrong. There's another point, a subsequent point you can make about that risk. So you'd argue Maturin's taken the risk that the fuel supply would be disrupted and they still guaranteed to supply it every day. Okay? You can make that point. How would you strengthen that argument? There's another factor in here. Not many people, well, few people got in the time pressure of the exam, but it was a one that strengthens that argument, that Maturin took the risk. Look at the negotiations. So you've got the problem about risk up here. Yeah. Okay, so they weren't prepared to take the risk of a 10-year period, but they were prepared to take it for 7. Excellent. Yep. Which again comes into the idea that they were aware of the risk that they were taking on a longer term. Yeah, there was another.
Could you also argue that the increase in the price that was being discussed reflects the increased risk that the contract brings?
Yeah, that was the point I was trying to make, is that Aubrey asked for the price to be determined on the international market, and the price they finally agreed to was the international market with a markup. And you could argue, you're not entirely clear on the facts, but you could argue that the reason for that increased price was that was Maturin's way of setting off the risk they were taking and having to supply this one airfield via a potentially risky supply chain. Great. Yep. Excellent. Other points at all, or any others? There was one other point about the price, or about the negotiations. Not only was the price increased, but Aubrey also accepted the obligation of having to buy a minimum amount each month, which was another way of Maturin offsetting the risk of a long-term supply chain agreement. That's to the detriment of Aubrey, because there's a few times where Aubrey didn't need 1 million gallons but still bought it. The point is that was a floor for Maturin, that they knew that they would always be supplying at least 1 million gallons and getting paid for it, whether or not Aubrey wanted it. Great. So that would be another argument to say that this was a risk that was priced into the contract itself. Yeah.
Could you argue that the Marsden point, and while this isn't entirely clear on facts, but the Marsden point risk is possible because there's been lots of discussion in Parliament about shutting down, passing legislation to close out the refinery, which is a different type of risk to a natural weather event destroying the supply chains.
Yes.
It's not a different type of risk.
Fantastic. Yeah, great argument. And that's, of course, what Maturin would argue is like, yes, we were concerned about the risk to the supply chain, the risk that Marsden Point would shut down, not the risk of a weather event that would destroy the pipeline. And that's why we increased the price. That's why we required a minimum spend by Aubrey. Excellent. Anything about the time frame? How long is the contract for again? 7 years. And how long has it been damaged for? How long has the pipeline been damaged for?
6 months.
6 months. Is there an argument there around looking at the contract as a whole, a breach of the supply for 6 months out of a 7-year contract is not a large enough interruption such that performance is radically different? Remember, that was one of the arguments put forward, and at least considered by the courts in Salam Air, that the inability to run the planes for a number of months had to be set into the context of the time frame of the contract as a whole. And I think you could strengthen that, or at least add to that point, by the fact that Maturin's perfectly happy to enter into a new fuel supply contract after the event has occurred. So this is not something where performance is unable to occur going forward. It's something that there's been a breach of the supply, there's been a break in the supply chain, but now that's fixed and the contract, or a new contract could begin, or as Aubrey said, the old contract could continue. Any other points or arguments that came up when you were discussing this at all? I think the strongest argument for Maturin is clearly this is a significant weather event that has obviously created a large disruption to all sorts of things. It has destroyed the pipeline. This was not a risk that we had contemplated for and provided for in the contract. Clearly, the parties would not have contemplated continuing performance under these circumstances. And then you've got the arguments against that from Aubrey, that this was a breach of 6 months within a 7-year contract. It can continue on after those 6 months. And that the contract was a risky one that Maturin entered into anyway. You could potentially argue, weather events do, 1 in 100 weather events aren't as uncommon as they used to be. So perhaps you can make some sort of argument about that. But the point is to be aware that obviously this question was written in such a way that there were good arguments, I would say, on both sides. And that I wasn't looking for a correct answer. I was looking for you to identify that this was a frustration question and to identify the law correctly, and then the application of the law to the facts and the identification of those facts that were relevant, and then a conclusion. Okay? So when you're answering a question like that, I'd spend a couple of minutes obviously reading it, looking at what the question actually is, and then planning out what facts you'll look at, and then get into writing it. Okay? You don't have a lot of time. As I said, 40-odd minutes. It's not heaps of time at all. Any questions at all about that? It'd probably be a good idea for you guys to go away and at some point practice writing the answer that you would write to this, and just see how much you can do in 40-odd minutes. All good? Happy? Okay, cool. Now that we remember what frustration's about, let's finish off by looking at what happens when a claim of frustration is successfully argued. So we've looked at when a contract may be frustrated or held by the court to be frustrated, which is that it's held to have been brought to an end and both sides are released from their obligations due to this outside event, which was not a breach by either party. So what we're going to look at now is what happens when the courts find that a contract has been frustrated. What was the effect of a finding of frustration under the common law? And what is the effect of a finding of frustration under statute? the statute was specifically designed and put in place to remedy some of the deficiencies in the common law. But as we'll see, I don't think it's a complete fix, and you need to know what the common law was to figure out what on earth the statute's talking about. So, the key point which explains all of these decisions is that a finding of frustration brings the contract to an end from the date of the frustrating event. It does not mean that the contract was void ab initio, that is, that it never existed. The common law position, which is still the position today under the statute, is that you had a valid contract which you entered into. That valid contract continued until the frustrating event occurred. And it was only after that frustrating event that the contract was void. And it's void and not voidable because frustration occurs automatically. It is not at the election of either party. So, but what effect does that have? As we'll see in the next couple of cases, the common law was extremely consistent, logical, but arguably unjust in the consequences that occurred because of a finding of frustration. So let's have a look at the first case, Appleby and Myers, where the contract was about the erection and maintenance of machinery in the factory of the defendant. What it was is what this contract is sometimes described as is what's known as an entire agreement contract, where one party, in this case the plaintiff, had to perform everything before they got paid by the defendant. So the contract was, you will build machinery in my factory. This machinery will increase the efficiency and productivity of my factory. You will keep this machinery in good repair for 2 years. And if you do all that, then I will pay you. So, the defendant had an obligation to pay only at the end of 2 years and only if the plaintiff had performed fully its side of the bargain. And you can see what's going to happen, right? So, the plaintiff builds the machinery, maintains it for a length of time, not for 2 years, because prior to the 2 years elapsing, a fire breaks out in the factory which completely destroys the factory and the machinery within it. And this was held to be a frustrating event. The plaintiff claimed from the defendant money to recognise the work that had been done on the defendant's factory. So I didn't do it for 2 years, so I can't claim under the contract, but I can still claim for effectively a quantum merit for the work that I have done. And the court says, well, let's have a look at the contract. What is it that was agreed to by these two parties? Firstly, the court said the defendant didn't have an absolute obligation to prevent a fire. So a fire breaking out wasn't a breach of the contract by the defendant. There was no evidence that the defendant lit it himself. And there was no absolute obligation to prevent fires, so therefore there was no breach by the defendant. Instead, the fire was a frustrating event. It rendered performance of this contract radically different. After the fire had broken out, obviously you needed the factory to be up and running to put in machinery to make it more efficient. The fires destroyed the factory, destroyed the machinery. The parties cannot have intended that this contract continues post-fire. So it's frustrated, which excuses both sides from any further performance. So that's fantastic for you, the plaintiff. You don't have to maintain machinery that doesn't exist anymore. Unfortunately, it also means that you, defendant, don't have to pay for anything, because the obligation to pay has not yet arisen. The 2 years have come up. So the plaintiff can't be sued for failing to keep the machinery going for 2 years, as he promised to do. But the owner of the factory is excused from having to pay anything. This was an entire agreement contract under which the plaintiff was not due to be paid until the work was completed and the 2 years had been, the property had been maintained for 2 years. You didn't maintain it for 2 years, and therefore you can't claim anything for the work that you've done. So the contract's frustrated, and the defendant for his work gets paid nothing. Why? Because there was no obligation to pay until the end of 2 years. That 2 years hasn't rolled around. The fire has frustrated the agreement. There's no contract to sue on for either side for further performance. That is why you might want to put into your contract, if you're building and maintaining machinery, a periodic payment schedule under which you get paid monthly, for example, rather than waiting for the very end of the contract. The court uses a case that we used to teach called Cutter and Powell, whereby a sailor was sailing back from a ship back from the Caribbean to London, Liverpool, I think, anyway, to England, and was to get paid upon the successful completion of the voyage. He died halfway through the voyage. His widow sued for wages, and the court said he doesn't get anything because he didn't work the ship back to England. He agreed to only get paid when he worked the ship home. He didn't work the ship home, so he gets nothing. Similar with this. Does it make sense? I only get paid at the end of the contract. The contract does not end naturally because it gets killed off by frustration. Therefore, there's no contractual obligation either for the plaintiff to continue to build and maintain the machinery, but neither is there an obligation for the defendant to pay the plaintiff for that machinery. Make sense? Happy? Good. Okay. The opposite type of problem comes from a case called Chandler and Webster, which is again one of these coronation cases of King Edward VII. And it's very much the same facts as Crell and Henry, whereby the plaintiff hired rooms to view the procession, and the contract was that you would pay for the hiring of these rooms prior to the procession taking place. In fact, it was, you hire these rooms and you pay me up front. The hirer had paid £100, but still owed £41 15 shillings on the higher price of £141.15. But what happened? The king got sick, the procession was cancelled, and that, the court said, frustrated the contract just as it did in the case of Crell and Henry. So the owner of the rooms does not need to provide them on the dates that they were to be hired. Why? Because both sides are relieved from any further performance of the contract after the date that the procession was cancelled. Any further performance. But any performance that was due and owing at the time of the frustrating event, at the time the procession was cancelled, still had to be performed. So the contract exists up to the date that the king got sick and the procession was cancelled. It ceases to exist going forward. But all the obligations that became due and owing prior to the frustrating event must still be performed. What was the only obligation that was due and owing at the time of the frustrating event? The only obligation that was due and owing was the hirer's obligation to pay for the rooms. So the court said that the contract's frustrated, but the hirer still has to pay the entire amount. This payment was not conditional upon the procession taking place, so it wasn't like Appleby and Meyer that we just looked at. It was instead, the contract was, we entered into this contract, you pay for the rooms now. That money was due and owing now, not after the procession took place. So the hirer couldn't get his £100 back, and in fact was ordered to pay the remaining £41 15 shillings. And in return, what does he get? Nothing. He can't even go and use the rooms, even though there's no procession going on. Why? Because the contract was frustrated and further performance was both parties were released from further performance. So here you had payment followed by performance, and you had a breach in the contract between payment and performance. In Appleby and Meyer, you had performance and then payment, and a breach between the date of performance and payment. So you can see that the outcome makes sense, right? Like, logically it makes sense, but practically what happens is that you get one party loses effectively everything and the other party does not. Is everyone happy and understanding with what the law said in Chandler and Webster and why? Yeah.
I'm not too sure why the court's decided this way. Why the person's not even get to use the rooms when you pay for them.
Why can you not even use the rooms?
Yeah.
Because the contract. Why would the hirer have what possible? Assuming nothing had happened, what right does the hirer have to use the rooms? On what basis can the hirer go up to the rooms and say, these are mine for the next 2 days? Yeah, but what legal right does he have? What basis does he have a right in law to go and use the rooms? Under a contract. Excellent. Exactly.
But he seems to pay.
Yes. Yes, that's 100% right. So he has no legal right to use the rooms because the contract has gone. He still has an obligation to pay because the contract was in existence at the date he had to pay. And I think the courts would say, well, you took the risk that something would happen. You took the risk that you'd have to pay up front and then you died and you didn't get to see the procession. Or there was a fire that broke out. Or the king got sick. Similarly, in the previous case, you took the risk that you would only get paid at the end of 2 years. The factory owner could have gone under. When you are obliged to pay up front, you're taking the risk that something will happen. Similarly, when you get paid at the end of the contract, you're taking a risk that something will happen. In this case, probably the reason why is that the demand for rooms was very great, and therefore the owner of rooms could require people to pay up front. And there's, whenever you hire a hotel and things like that, often you have to pay up front. The refund policy was not great on this contract, I have to admit. But does that make sense why that occurred as a matter of law? Because the next case, Fabrosa Spolka, is the House. So this was a Court of Appeal decision in the UK. The next case is a House of Lords decision about 40 years later, 30 years later, where the House of Lords is saying, we don't like Chandler and Webster, we're not bound by it, and therefore we are going to try and soften it somehow. Right. So Fabrosa Spolka, a 1942 decision arising from the outbreak of war between Germany and the UK. That's a photo of the bombardment of Gdansk in Poland, which was exactly where the goods were to be delivered under the contract in question. So this is a reverse situation from Appleby and Meyer. It's similar to Chandler and Webster, where the money was paid but nothing was done in return before the frustrating event. So here you had a contract whereby goods were to be delivered to Gdansk in Poland, and there was a payment scheme whereby at least some of the purchase price was to be paid up front as a deposit. So what happened? The contract was entered into in July 1939. Germany invades Poland when? Excellent. 1st September, so a couple of months later, before the goods had been shipped. And as soon as Germany invades Poland, firstly, it's very dangerous to get to Gdansk, and even if you can, actually, Poland fell relatively quickly, and so you would be delivering goods not to Polish Gdansk, but German-occupied Gdansk, which would be, of course, supplying the enemy, which would be treason because Britain's at war with Germany. It is legally impossible, even if it was physically possible, which is arguable, it is legally impossible for this contract to continue. So the outbreak of World War II and the overrunning of Gdansk was a frustrating event. It would render performance radically different. There's no question. It's clearly frustration. The only question was whether the buyer's advanced payment for the delivery could be retrieved from the seller. This is exactly the situation that we just saw in Chandler and Webster. And Chandler and Webster, the coronation case we just looked at, would say yes or no. Can the advance payment? No. Why not? Because the payment was due and owing prior to the contract being frustrated. And therefore performance due and owing prior to frustration still has to be performed. It only relieves you from obligations after the date of frustration. However, the House of Lords effectively overturned Chandler and Webster. And the House of Lords says, where there is a total failure of consideration, that is, when performance has failed completely, there is nothing that you got under the contract in return for your payment, then you can retrieve that amount. So be careful. They're not talking about failure of consideration, which means there was never a contract. It's nothing about consideration as a formation requirement. What this meaning for consideration here to mean is you have paid money and you, in actual fact, have got no performance back. Because, of course, you could say in all these cases, there's always consideration, even if there's no performance, because the promise to perform is legal consideration. So they're not saying there's no consideration because there's no promise to perform. There clearly was. What they mean is that promise to perform didn't substantially equate to actual performance. So you made an advanced payment for these goods to be shipped to Gdansk. You got nothing in return for that advance payment. There has been a total failure of consideration. And therefore, because you've got nothing under the bargain in return for that money, you can get that money back. And this was clearly to soften or obviate the harshness of earlier cases that we just looked at, like Chandler and Webster. But the House of Lords makes a very interesting point. They say the problem, this is not a total solution. It doesn't, this decision in fibrosis Spolka does not help in every single situation. In particular, if we allow the return of money for a total failure of consideration, that, in this case, would help the buyer of the goods, but that could leave the seller out of pocket. If the seller has itself spent money in trying to perform this contract that then is frustrated. So if the seller of the goods had had to go and spend money making the goods, for example, prior to the contract, they will be out of pocket if they then have to return the deposit, as they do in this case. And the court says there's really nothing we can do about it. There's no common law tool we can do to say that an innocent buyer must refund the money that an innocent seller has spent trying to perform a contract where that seller has not provided anything to the buyer because it's been frustrated. There's nothing we can do about that. We can require the money to be returned, which helps the buyer in this case, but that might leave the seller out of pocket. And what the court is really getting at here is that frustration cases are cases where both parties are innocent. It's outside the control of either party. It's not due to their fault. And that often both parties will lose out, or at least one party will lose out. And it can be very hard to ensure that everything is fairly squared away so that justice is done to both parties. And the court says, look, we really need Parliament to have a go at doing some sort of restitutionary fix through statute. And amazingly, despite this being 1942, the very next year, the UK Parliament, whilst World War II is raging, passes the much more important Frustrated Contracts Act. You put aside all the war work, we're going to get there and solve what's happening with frustration. So in 1943, the UK Parliament takes on board the concerns of the House of Lords in fibrosis Spolka and passes an act called the Frustrated Contracts Act, which seeks to provide some restitutionary relief in frustrated contract situations. And New Zealand, because we were smart back then, we used to just copy what everyone else was doing and change the name from UK to New Zealand. The next year after that, so 1944, we took the UK's Frustrated Contracts Act and almost entirely, it was word for word almost exactly the same. And so that Act has now been subsumed by the wider Contract and Commercial Law Act, particularly Section 60 through to 69, which tries to deal with these situations. And that's what we're going to look at on Wednesday. So I want you to have a look at sections 60 to 69. Read all of them, it's only like 2 pages. And try and figure out how and to what extent these sections solve the problems identified in these cases. To what extent do they solve the problem of Appleby and Meyer, where you have performance prior to payment? To what extent do they solve the problem of Chandler and Webster and Fabrosa Spolka? Yeah, we've still got 5 minutes. What are these people doing? Go away. To what extent do they ensure that justice is done between the parties? You might find that the answer is something, but it's not perfect. Okay, so read 60 to 69. Read the case of Gamerco, which is all about Guns N' Roses, except in a frustration law context, which is not quite as interesting. And so you can see how the courts in the UK, using substantially similar law, is applying the Frustrated Contracts Act. Okay, but before we do that, is there any questions at all about Fabrosa, Chandler, Appleby and Myers? Happy? Good. Okay, you can leave early then. Go and read the Contract and Commercial Law Act, and I'll see you on Wednesday.
I was gonna